For 90 years, one law has stood as the cornerstone of America's gun restrictions, the National Firearms Act, a law born in 1934 when lawmakers decided that if they couldn't outright ban certain firearms, they would bury them under taxes, paperwork, and delay. Suppressors, short-barreled rifles, short-barreled shotguns, all locked behind a system designed to keep them out of reach. But today, that system is breaking. For the first time in history, the $200 tax stamp that propped up the NFA has been reduced to zero. And with that single change, the legal foundation of the entire law has cracked. Now, the question isn't whether suppressors and SBRs should be free of the registry. It's whether the government even has the constitutional authority to enforce the NFA at all. Lawsuits are moving fast, politicians are panicking, and the courts are being forced to answer questions they've avoided for nearly a century. This isn't just policy, it's a nationwide turning point that could reshape the Second Amendment, federal gun law, and the future of firearms ownership in America. And in this breakdown, we're going to cover it all. How Congress triggered this collapse with H.R. 1, why opponents are scrambling to restore or even increase the tax, the lawsuits designed to tear down the NFA piece by piece, and most importantly, what this means for you, your rights, and the future of American gun laws. This is the story of how a single change set off a legal earthquake. We cut through the noise and give you the truth about the cases, the bills, and the rulings that shape your rights. So if you're serious about staying ahead of these battles, make sure to subscribe right now so you never miss a single update. Let's break it down. Chapter 1. The Cracks in a 90-year-old Law. The National Firearms Act wasn't born in calm times. It came out of the 1930s, an era when America was gripped by fear of gangsters, bank robbers, and public shootouts. Politicians wanted action, and what they delivered was the NFA of 1934. But here's the truth. Most people don't know. The NFA wasn't originally designed as a straightforward gun control bill. It was crafted as a tax law. Why? Because in 1934, Congress didn't think it had the constitutional authority to outright ban firearms. Instead, they leaned on Article 1, Section 8, the power to lay and collect taxes. They knew they couldn't forbid you from owning a suppressor or a short-barreled rifle, but they could make it so expensive and so burdensome that hardly anyone would try. And it worked. The $200 tax wasn't pocket change. Back then, $200 equaled about $5,000 in today's money. For ordinary Americans, that might as well have been a ban. For decades, the courts upheld this scheme. The Supreme Court itself said, Congress has the power to tax, and that's all the NFA is. That single argument kept the law alive for nearly a century. But when Congress passed H.R. 1 in 2025 and slashed the $200 tax to zero, they pulled the rug out from under the NFA's only legal foundation. Without the tax, what authority remains? That's the crack in the wall that could bring the whole structure down. And that's why the fight today is not just about suppressors or short-barreled rifles. It's about whether the federal government can continue enforcing a law that no longer has its constitutional anchor. Chapter 2. The Backlash and the $479 Proposal. The reaction to H.R. 1 was swift and furious. Supporters of the NFA knew exactly what was at stake. Without the tax, lawsuits would inevitably argue that the law itself was unconstitutional. So Senator Chris Murphy stepped forward with a plan. His amendment to the military spending bill aimed not just to restore the tax, but to increase it to $479 per item. Why $479? That number wasn't random. It was designed to mirror history. In 1934, the $200 tax was crippling, designed to keep people out. Adjusted for inflation, Murphy's proposal lands in the same territory, nearly $500 per suppressor or short-barreled rifle. It's not about raising revenue. It's about restoring the NFA's legal justification and pricing ordinary Americans out of ownership. It's the original 1934 playbook, dusted off for 2025. But here's the key. The fact that Murphy and others are scrambling to reinstate a tax proves something important. It proves they know the NFA is vulnerable. If they truly believed the law could stand without the tax, they wouldn't be rushing to rebuild it. And this panic gives Second Amendment advocates their strongest signal yet. The other side isn't confident. They're afraid the courts might finally do what politicians have resisted for decades: strike down the NFA's restrictions entirely. Chapter 3. Lawsuits on the attack. Within weeks of H.R. 1's passage, the lawsuits began. Gun Owners of America, FRAC, Palmetto State Armory, and Silencer Co. launched a direct challenge in federal court. Their argument was clear and simple. The NFA was only upheld as a tax. Congress has now reduced that tax to zero. Therefore, the law no longer has constitutional authority. It's a devastating line of attack, because the courts can't simply invent a new justification. The NFA wasn't passed under the Commerce Clause. It wasn't passed under the Second Amendment. It was passed and upheld as a tax. And now, that tax is gone. These lawsuits are asking courts for two things: a declaration that the NFA's registration and transfer requirements exceed Congress's powers under Article 1, an injunction blocking the ATF from enforcing those requirements on untaxed firearms, specifically suppressors and SBRs. In plain language, they're asking judges to admit the NFA is unconstitutional in its current form and stop the government from enforcing it. It's not just one case either. Multiple suits are being filed across the country, coordinated to create pressure from every angle. The strategy is simple: force the courts to confront the reality that the NFA no longer rests on a constitutional foundation. Chapter 4. The state-level battles. While national groups attack the NFA itself, state-level organizations are taking aim at local bans. Groups like the Firearms Policy Coalition, FPC, and the Second Amendment Foundation, SAF, are suing states that continue to outlaw suppressors or short-barreled rifles outright. Their argument? If the federal government no longer taxes or justifies these items, then states cannot impose blanket bans either. This two-pronged approach, federal lawsuits against the ATF, state lawsuits against local bans, is a coordinated effort. On one side, dismantle the National Registry. On the other, strip away state prohibitions. Together, the strategy is to create a domino effect, and the timing matters. By hitting both levels at once, advocates maximize pressure and minimize the chance of courts ducking the issue. If one judge says, "Not my problem," another judge in another jurisdiction will be forced to weigh in. This is how big constitutional shifts happen. Not with one case, but with a wave of cases all pushing in the same direction. Chapter 5. Why this fight matters. Some might ask, why does any of this matter? After all, isn't this just about a tax? But here's the truth. This is about much more than money. It's about the government's ability to justify restrictions on your rights. For nearly a century, the NFA survived on one argument: it's a tax, and Congress can tax. That argument gave cover for the registry, the wait times, the background checks, and the restrictions. But now, with the tax at zero, that justification has collapsed. If the courts agree, then the registry itself becomes unconstitutional. That would mean suppressors, short-barreled rifles, and short-barreled shotguns could no longer be restricted under the NFA framework. And if the NFA falls here, it opens the door to broader challenges. What about forced reset triggers? What about pistol braces? What about so-called assault weapon bans that piggyback on NFA definitions? The ripple effects are enormous. This isn't just about saving a few $100s on a suppressor. This is about tearing down one of the pillars of federal gun control, and that's why the lawsuits, the counterbills, and the political panic all matter. Because what's happening right now could reshape firearms law for generations. Chapter 6. The Courtroom Battlefield. The lawsuits filed by Gun Owners of America, FRAC, Palmetto State Armory, and Silencer Co. aren't just symbolic. They were carefully placed in the Northern District of Texas, a federal court known for issuing some of the most important pro-Second Amendment rulings in recent years. This district gave us rulings on 80% receivers, pistol braces, and forced reset triggers, cases that rattled the ATF and forced higher courts to weigh in. Filing here was no accident. Advocates know this court is fertile ground for a serious challenge, but there's a catch. The judge assigned, Judge Hendricks, has little history on Second Amendment issues. That means the outcome at the district level is uncertain. If the ruling goes against gun owners, appeals will shoot up to the Fifth Circuit, a court with a stronger track record of siding with constitutional rights. And from there, the Supreme Court could be one step away. That's why this isn't just one case, it's a strategy. Win or lose at the first stage, these lawsuits are designed to climb the ladder until the highest court in the land has no choice but to decide, can a law that rests on a tax survive once that tax has been reduced to zero? Chapter 7. The Gun Owner's Reality Check. For most people, the idea of suppressors or SBRs may sound like a niche issue, but here's the reality. If you're a gun owner, this fight directly affects you, even if you never plan to buy either item. Why? Because the NFA set the template for how the government regulates firearms. Background checks, registries, waiting periods. Much of the modern system is modeled on the logic of the NFA. If the courts strike it down, it doesn't just free up suppressors and SBRs, it cracks the logic behind dozens of other restrictions, and that means everyday encounters matter more than ever. Imagine being pulled over and telling an officer you're carrying legally. Imagine a mistaken knock at your door under a red flag order. Until now, courts often judged those encounters based on the final second, whether the officer felt threatened in that split moment. But under this new wave of challenges, context matters. The officer's choices, your actions, and the full sequence leading up to the use of force all become relevant. For responsible gun owners, this is long overdue. It means you can no longer be blamed for a tragedy just because you were armed. Courts will have to weigh whether your lawful actions were misunderstood and whether the government went too far. This is why the current NFA battle matters. It's not just about specific firearms. It's about restoring balance between citizens and the state, especially for those who lawfully carry. Chapter 8. The Second and Fourth Amendments converge. For decades, the Second Amendment and the Fourth Amendment were treated as separate arenas. One protected your right to keep and bear arms. The other protected you from unreasonable searches, seizures, and government overreach. But the lawsuits against the NFA and the tax changes that triggered them are forcing these two amendments to converge. Think about it this way. The Second Amendment protects your right to carry, but that right is hollow if the Fourth Amendment doesn't protect you from being harassed, seized, or punished just for exercising it. That's why this fight is bigger than suppressors. If courts rule that the NFA can't stand without a tax, they'll be saying something profound. Lawful gun ownership cannot be treated as inherently suspicious or dangerous. This creates a shield for gun owners. No longer can the government argue that simply carrying certain items makes you an automatic threat. Instead, they'll have to prove with context that actual danger existed. For the first time in history, the Second and Fourth Amendments may be reinforcing each other, working together to protect lawful citizens in ways the founders likely intended, but modern courts have resisted. Chapter 9. The Road Ahead. What happens if the NFA falls? So what happens if the plaintiffs succeed? First, the registry for suppressors and SBRs could collapse. If the tax stamp is unconstitutional, then requiring registration for untaxed items collapses with it. That alone would be a seismic shift, but it doesn't stop there. The logic used to dismantle the NFA here could spread to other areas. Pistol brace regulations that piggyback on NFA definitions, restrictions on forced reset triggers, even broader assault weapon bans that rely on the same justifications. If the courts strike down the NFA on the grounds that no tax means no law, then every restriction modeled on NFA logic suddenly becomes vulnerable. On the flip side, if the plaintiffs lose, the fight won't be over. Appeals will continue, more lawsuits will be filed, and the question will keep climbing until the Supreme Court answers it once and for all. That's why both sides are fighting so hard now. Everyone knows this is a historic moment, one that could redefine firearms law for decades to come. Chapter 10. Why this moment matters for every citizen. At the end of the day, this battle is about more than guns, suppressors, or SBRs. It's about whether the government can keep laws alive on the flimsiest of justifications, even after their original foundation has disappeared. If the NFA survives without a tax, then Congress could argue that any law, no matter how burdensome, can be justified retroactively under some other power. But if the courts strike it down, it sets a precedent that laws must stand on the grounds they were originally built upon. That principle matters to everyone, not just gun owners. It's about honesty in lawmaking, accountability in governance, and the limits of federal power. And that's why this fight is so critical. Because whether you own firearms or not, the outcome of these cases will shape how much power the government has to regulate your life and how much protection you truly have under the Constitution. So here's where we stand. The $200 tax that propped up the National Firearms Act for nearly a century is gone. Lawsuits are hammering the ATF from every direction, and in courtrooms across the country, judges are being forced to answer a question that politicians have dodged for decades. Can a law survive when its only constitutional foundation has been erased? The answer to that question will decide far more than just suppressors and short-barreled rifles. It will decide whether the government can keep resurrecting old restrictions after their legal basis has vanished, or whether the Constitution finally draws a hard line in the sand. And make no mistake, this is not just a courtroom drama. It's a turning point in American history. If the lawsuits succeed, the registry collapses. If the lawsuits fail, the appeals will climb higher, and the fight will continue, maybe all the way to the Supreme Court. Either way, this is the most significant challenge to federal firearms law in nearly 100 years. Now I want to hear from you. Do you think the courts will finally strike down the NEFA's restrictions, or will Congress find a way to keep the system alive? Drop your thoughts in the comments, because history isn't just happening in Washington, it's happening right here, in the debates we have as citizens. If you found this breakdown valuable, share it with someone who needs to understand what's really at stake, because we'll keep cutting through the noise and bringing you the truth about every battle that affects your rights. Stay informed, stay prepared, and above all, stay free.